Here's the number one question I have. Upon hearing that the prosecution was seeking lesser charges, why didn't they do that from jump? Why all of a sudden is this a thing now? Is it because they realize that they put on a crappy prosecution?
Well, you know, I don't think I would characterize the prosecution that way, Jonathan. The problem with this trial is that it's been under a microscope, and sometimes things don't look very good as you're watching the sausage get made. It's not uncommon to see lesser included offenses come up during the judge's charging conferences as the judge is talking with the parties about how he should instruct the jury. But in a case like this, it may well be an acknowledgement that not everything has gone precisely as the prosecution would have hoped. On the other hand, these lesser included offenses are still very serious charges that carry lengthy sentences along with them. A conviction on lesser included offenses here would be a victory. The real concern that I have is this. Conviction in a criminal case, of course, takes a unanimous jury. And having tried a number of civil rights cases, not this sort of a murder prosecution, but cases where we indicted a police officer or someone else for a civil rights crime, very often you have juries that are unable to reach unanimous juries, a hung jury. That's a possible outcome here. That would mean that we would go through this trial a second time. Second trials are never as good for the prosecution, although, you know, this has been an unusual trial in many regards. But that said, these lesser included offenses I don't find to be troubling. I'm more worried about the risk of a hung jury. If the lesser included offenses help the jury get to unanimity, then I'm all in favor of them.
Maya, I would love your view on that. But also, I mean, Joyce brings up the concern about a hung jury. There are others who are like, this prosecution's going to lose, and there are others saying that there could be a mistrial. We just put up the story from the Washington Post, the headline, "He Could Lose It," about legal experts seeing about the prosecution's missteps, where Janine Geske, a former Wisconsin Supreme Court justice, said, "I think he's cutting corners as close as he can to get his evidence in front of the jury. Unfortunately, he's really angered the trial judge." And then you have in Newsweek, why a Rittenhouse mistrial is unlikely, which is my concern that there would be a mistrial. It says the judge would need to prove that Binger prevented Rittenhouse from receiving a fair trial and that his conduct was, quote, outrageous, calculated, and provoked a mistrial. So, Maya, if Joyce is concerned about a hung jury, are you concerned about a hung jury lost by the prosecution or the likelihood of a mistrial, or none of the above?
Well, I'm concerned about all of it, although I think a mistrial is unlikely. I'm definitely in the category of, I don't think this is a mistrial situation. I don't think the judge is going to see it as a mistrial situation. I also think that Joyce is absolutely right about the importance and possibility of conviction for lesser included offenses. Remember, actually, the most serious charge in this case is the murder charge for Mr. Huber, who is the second man Kyle Rittenhouse killed, who had the skateboard. If that becomes a lesser included offense, he could still get 25 years for reckless endangerment if he's convicted of it. So I do think it's important. I was a little concerned that the judge in this case, and I think we should mention that this jury could become a hung jury. If it does, I think in part, it's going to be because the judge communicated, in my view, let's say some bias, okay, in this case. And he communicated it in different ways. We had the issue most recently of Veterans Day, where he asked about veterans in the room, and the only veteran in the room was a defense witness, And then he called for the room to clap for the veteran. Now, if he had said, any veterans in this room, let's all applaud for any veterans who served, but not singling out. And there were other aspects of his behavior that I think, and there is research behind that judges do communicate, sometimes even non-verbally, in ways that juries get. And they're using the judge as the neutral arbiter sometimes to understand which side is doing a better job. So these things, some of these subtle things that we've seen throughout this trial that Joyce is right has been under a microscope matter. And I want to say one other thing, Jonathan, because you usually ask, what are we not paying attention to? You know, the larger context here. Jacob Blake, the reason there was all that activity that resulted in Kyle Rittenhouse showing up with his AR-15, violating Wisconsin law, violating a curfew, was because Jacob Blake was killed by a police officer, and his uncle, who's also named Jacob Blake, has been in that courtroom outside that courthouse every single day hoping for justice for somebody. And in this case, it's the victims of Kyle Rittenhouse.